Welcome to another seminar in our series of Pulling Back the Curtain, where we try and discuss things that buyers and sellers of residential real estate should know before and during the process to try and get the uh, have the best opportunity to make the best deal. If you've got questions as we go along, these seminars are designed to take 15 or 20 minutes of time, and we leave a little bit of time for questions. If you do have questions, you can type them into the chat box and we'll try and answer them as we go along. Or if not, we'll answer them at the end. And if some of you have to leave, that's fine. You can always email us or give us a call after if you've got questions, and we'll give you our contact information at the end. This is going to be a seminar about critical clauses in the the Pennsylvania Association of Realtors Agreement of Sale, and some addendums that you really need to understand when you're negotiating the contract. We're going to talk a little bit about some of the programs. If you're selling or buying, my company has special programs to save you thousands of dollars, no matter if you're a seller or a buyer, in addition to getting quality representation. A little bit about me. I've been a member of the West Penn Multi-List for over 22 years. I've got 3 decades of legal experience. I own a mortgage company called Advocate Mortgage. We've closed hundreds of millions of dollars of mortgages over decades. I've actually personally closed hundreds of loans and issued thousands of title insurance policies. I'm a certified financial planner and registered investment advisor. So I can actually take care of handling every part of your transaction without you needing to go anywhere else. I can help you find a house, find a mortgage, conduct the closing. Again, we love buyers. We're saving them thousands of dollars, pick up thousands of dollars of closing costs. Same thing for sellers. We're picking up thousands of dollars of closing costs for them that will actually help them make a better deal. For example, in our seller, one of our programs for sellers is we agree to reimburse them for a home inspection and an appraisal from our commission. So the sellers tend to not want to spend money, but they don't always understand that, hey, you're spending tens of thousands of dollars in this transaction. Spend a few more and get the information that will save you tens of thousands of dollars. And we can explain to you why that's so. But we'll get into more detail either later or in another webinar. So one of the first things you should do, no matter if you're selling or buying, is get the real estate contract, the standard contract, which is 14 pages, and you read it early. And even if you don't understand it totally, we would explain it to you. We'd go through the paragraphs and tell you, this is when this comes into play. This is when that comes into play. Some clauses favor buyers, some clauses favor sellers. So just filling in the blanks does not really do you justice. And then once you sign a contract, there are rights and obligations that take place, and you may be giving up rights or taking on obligations that you really didn't intend to. So you got to read the contract. You've got to read the seller disclosure early, the blank forms, before you even get started. If you're reading them when you're presenting an offer or accepting an offer or receiving an offer, it's really too late for you to thoroughly understand the significance of all the provisions. The clauses we're going to go over today are the home inspection contingency clauses, paragraphs 11, 12, and 13. We're going to talk about paragraph 25 and the representations that are in there that can limit your liability if you're a seller, cut off your ability to get remedies if you're a buyer, the default and termination clause, mediation. You think you can sue somebody if there's a breach of the contract? Maybe, maybe not. And the release, which is a wide release by the buyers of everybody, including people that are even part of the contract. So we're going to go over these today. We'll start with 11. Very short paragraph. If you're a buyer and you elect to do one of the inspections that are contained in the contract, but you don't do it, then you've effectively waived it and agreed to the release in paragraph 28. So if you elect an inspection and don't do it, it's got some serious legal consequences for you. And that's good for a seller. They'll want you to do that. Yes, elect it, and if you don't do it, that relieves them of a lot of liability. typically, unless you put the right clauses in the contract. Paragraph 28, again, the release. The release, buyer releases everybody. Very favorable to seller. All claims, losses, demands, or defects or conditions on the property, except there's a provision in there, if the seller's in default or in violation of the seller disclosure law, you can pursue remedies at law or equity, and it says the clause survives settlement. But you have to square that with paragraph 25 that states that you as a buyer are not relying on any representations. So the question is, are the representations in the seller disclosure that you receive, can you actually claim that you've relied on them and get more remedies than just under the seller disclosure law, because it would be a violation potentially of the UTP CPL law, Unfair Trade Practices Consumer Protection Law. It's not clear, but if I'm representing a buyer, I'm putting in, if possible, again, this is all a negotiation, but if possible, I'm going to put representations in there that would help you bring claims for more remedies than if you don't. So we'll try and talk about this in a little bit as we go through the slides. Paragraph 25, representations, is very seller friendly. Okay, again, I told you some paragraphs are buyer friendly, like the home inspection contingency clause, very buyer friendly. So the contract has lots of provisions where it favors the buyer during the contract, but at the end of the contract, once there's a closing, the seller is heavily favored unless you make certain adjustments. So in paragraph 25, it says all representations made by the seller are not part of the agreement unless expressly incorporated. So does that seller disclosure, is that part of the contract or not? And if you don't include it, if you don't expressly incorporate it, the seller's got a good argument that you didn't rely on it. So again, this agreement, the paragraph says, this agreement contains the whole agreement, no other representations of any kind whatsoever. Second part of this paragraph says the buyer inspected the property before signing the contract or waived the right and agrees to purchase in the present condition except for inspections elected. And typically you buyers have seen the property, if not in person, by video. I hope that buyers, I think it's problematic for buyers to buy just based on photos, and even videos can make it challenging to know exactly what you're buying. But again, the paragraph says that the buyer has inspected the property and acknowledges the brokers haven't inspected the property or determination or made determination of permitted uses. You'll see lots of stuff in the contract that favors brokers too. They're not part of the contract. We are not part of the contract. What's the effect of this? I'm not sure. Repairs are done in a workmanlike manner, and the broker can help unrepresented parties. I don't know why that provision is in there in representations. There must have been a case somewhere where that applied, but largely the meat of it, of paragraph 25, is the upper part where the buyers pledging that they have not relied on any representations that are not part of the contract. How do you square these? Again, 25 and 28. I didn't insert a clause if you're relying on anything in the seller disclosure, if you're a buyer, to make sure that it's part of the contract and survives settlement. It's the seller disclosure law. There's a law that requires sellers of certain properties, not all properties, largely 1 to 4 family properties, residential, to disclose any material defects. What's material defect? Those things that can hurt the property value or cause injury on a high level. You have to, as a seller, you're obligated to provide the seller disclosure before signing. You can give it to the buyer directly or to their agent. The seller has no duty to investigate, so they don't have to go and do any inspections. We think it's probably a good idea for them to do that, but for the purposes of the seller disclosure, there's no duty to investigate. They do have a duty to update if they find anything that is a material defect. Again, there's a difference between a problem and a material defect, and there have been cases out there that deal with whether or not you have to disclose if there was a suicide in the house, and that is not a condition of the property. So you don't have to disclose that. But if you find that there's uh, a, a problem with your septic system or your well, you know, even if it's after you sign the contract, you have the duty to disclose that. And the standard is you cannot willfully or negligently fail to do these things. You have a duty to not make representations or have reason to know that the representations are false, deceptive, or misleading. And you have a duty to disclose all, again, material defects. The seller is liable for actual damages under this. If you're violating other laws like fraud or the Unfair Trade Practices Consumer Protection Law, there are attorney fees and triple damages, they're called treble damages. But under the seller disclosure, the seller is only liable for actual damages. There's a 2-year statute of limitations. The form itself says that the seller's only disclosing material defects, and it's not a warranty of the seller. And the buyer is encouraged to address concerns about the condition of the property. So again, it's a representation at the beginning of the transaction by the seller of the condition of the property without any duty to investigate. If you don't incorporate the seller disclosure into the contract, my opinion at this point in time would probably be that it's not part of the contract. And while you can sue the seller under the seller disclosure law, you can't sue them successfully for a breach of contract with laws that provide other measures of damages that are greater. Paragraph 12, buyer's duties is very buyer friendly. I mentioned this before. Some paragraphs are buyer friendly, some are seller friendly. The home inspection clause, paragraphs 12 and 13 are very favorable toward buyers. The seller has to provide access to certain professionals, and unless you agree otherwise in writing, only the parties and the agents can attend the home inspection. It's not for family members. You can agree otherwise, but there have been issues where family members come and start creating more issues than may otherwise have occurred. As a buyer, you get 2 pre-settlement walkthroughs, but it's only to determine that the condition of the property is as it was agreed to. It's not for things like measuring. Although if the seller doesn't mind, you can do that, but the purpose is only to make sure that it's still in the same condition that the house was in when you signed the contract. And you have 2 of those, and I would suggest to you to not wait till the very last minute to do these. You may want to do one walkthrough a week before and another walkthrough several days before. Seller has the obligation, so you can deal with any issues that come up. If something was supposed to have been left and the seller took it maybe accidentally, you want to be able to correct that before closing. The seller is required to have the utilities on for inspections, and that part of the clause is highlighted. We're not exactly sure why they think that that's important, but it's problematic in some instances where you have a relocation company or a bank, and they're going to tell you no. Largely, they're going to say, if the house was winterized, you want to pay to de-winterize it, do your inspections, and then pay to re-winterize it. You can't. What's your remedy if you're a buyer? Hey, terminate the contract. But you know, it's a practical problem. The seller's supposed to have one, doesn't always happen. The seller is entitled to a free copy of the inspection report on request. They don't get the appraisal, but if they ask you for a copy of the inspection report, you as a buyer have to give the seller a copy. And a home inspection, by definition, is when there's an inspection of more than one system. So a home inspection is not an electrical inspection, it's not a plumbing inspection, it's not a heating inspection. But if you're doing more than just one system, somebody's inspecting more than one system, and that's a home inspection. And if that's done, you have to have a home inspector that's a member of a national association or certified certain licensees, like engineers or architects. It's not Uncle Bob. So if you bring Uncle Bob to do your inspection and they find problems, you could have an issue with the seller claiming that you waived your right to do the inspections because you didn't do it properly. There are 9 different inspections in the contract. There's one maximum time period for all the inspections, and these take weeks. They legitimately take weeks. You want to look at the seller disclosure and get a heads up so that you may decide at the very beginning, in addition to the home inspection, maybe you want to get a roof inspection. You look and you see that on the seller disclosure, the roof is 30 years old. Well, the home inspector may tell you, look, I'm not a roofer. You probably have to get a roof inspection. It's another fee, but the cost of roof can be $20,000, $30,000, $40,000. You probably want to spend a couple of $100s and get that inspection early. And by the way, a material defect is not, if something is at the end of its life, if the roof's at the end of its life, it's not a material defect. It specifically exempts that in the law. If you do, you have to do your inspections, all of your inspections, get the reports, and either decide if you want to terminate the contract, accept it, or submit a proposal to the seller in the time frame submitted. It's, again, you don't want to miss the time frame because all these times are very important. It's called time of the essence, which means these are dates that have to be adhered to, or they're potentially waived. We talked about, again, there's 9 of these inspections. The home inspection, you get a termite report, it's a pest report, wood-boring insects, and if there's damage, you have to decide whether or not you're going to treat it, or if there's an active infestation, whether or not you're going to treat it, and if there's damage, if you're going to ask the seller for some kind of remedy. Easements and use restrictions, you want to verify that the current use is permitted. In fact, in paragraph 14, there's a default provision that if you don't, when you sign a contract, that you agree that you're going to get a title search. That's essentially what this is. You want to know, especially if your use, if you intend to put a pool in the backyard, you want to know if there's an easement running through the backyard that may prevent you from putting the pool in. You got to let your agent know, or your attorney, or if we're working with you, us, know what your intended use is, so we can help you get the information to verify that you can use the property for its intended use. Maybe the property is being used in violation of certain zoning ordinances, like a mother-in-law suite. You want to make sure that if it's being used as a 2-unit, is that within the zoning board know that that's how it's being used. Radon, while this is a problem, this is a manageable problem. Sometimes you have to test it over time, but you can install ventilation for probably $1,000 or so if there is radon, so it's not a fatal problem. If you're a seller and you're selling a property with a well or septic system, you should read the contract, because you've got certain obligations to provide the location and access and water. And if the buyer wants to do tests, you have to maybe bring in a lot of water for the test to be done. And then if you had to tear up part of the yard for this, your obligation is to put it all back into place. And by the way, this could be very hard to do in the wintertime. So you may, if you're going to put your house on the market, you have a well or septic system, you may want to do these tests, get these tests done in advance to give to the buyer. And the buyer can do their own tests, but it certainly goes a long way if you can provide a recent test on the well and the sewage system. Insurance, you want to always check to make sure that, call your insurance agent, have them run a clue report. It's a report that talks about claims. I think it goes back over the last 5 years. It can affect how much you have to pay for your insurance, and also whether or not the property needs flood insurance. And the flood maps change. And while an area may not be in the flood zone today, it could be determined in the future. And flood insurance can be very expensive. And by the way, if you need flood insurance, you got to order that in advance, probably at least 2 weeks in advance. So you want to call your insurance agent. I would elect this inspection, and this is work. But if you prepare in advance and you know what you're going to have to do, it's not as problematic. You can have the people lined up and So just start making your phone calls once you sign the contract. Boundary lines. A lot of people do not get, buyers do not get boundary line surveys. Now, there's a difference between a boundary line and an American Land Title Association survey. The boundary line is going to give you basically what the boundary lines are. The ALTA survey is going to give you a lot more detail about the location of easements, for example. Shared driveways, a sewer easement. So if you intend to use the property in a certain way and it's important, ALTA surveys can be 5 times as expensive as a boundary line. Boundary line survey can be $500. And if you're a buyer and you're buying through us, we actually reimburse you for the cost of a home inspection and a survey. We get a call a month from people that have had problems with boundary lines because they thought the fence or the hedges represented the boundary and it didn't. So, and if you're relying on the seller's representation of how much land there is, 1 acre, 1.5 acres, you want to get a survey to determine that. If your house was built before 1978, you can get sellers are obligated to let the buyers know that, and you can get a lead-based paint test, but you can't undo the paint. So you have to take a look at that because all houses before 1978 had lead-based paint. And if there are inspections that don't apply, for example, if you're a seller and you did a home inspection and there are things disclosed on the home inspection, you can attach that to the seller disclosure and you can put in this paragraph that any conditions disclosed on the home inspection are not conditions which the buyer can rely upon to terminate the contract. Very important if you're a seller. Then there are warnings paragraphs about wetlands, mold, asbestos. There are a lot of little clauses in here in the standard contract. They're just warnings. They're not really terms of the contract, but they're warnings. So again, read the contract early in case any of these things apply and you're concerned about it. Wetlands, mold, asbestos. It's all buyer beware. Paragraph 13, the inspection contingency. So how does this work? Once you sign the contract, from the date of the execution date, which is the date that all parties have accepted the contract, when they've accepted and initialed, and then that's the execution date. And from that date, not counting that date, days are counted. And so you have to do your inspections within that period, with the exception of an on-lot sewage system that may need to be replaced. We don't get a lot of those in this area, but just keep that in mind. If you have a septic system, there are special rules for that. But the buyer, if the reports the buyer gets are satisfactory, that's the standard. The buyer agrees to give those to the seller. The seller may not want them, but you will accept the property and agree to the release. You're always agreeing, if you're a buyer, agreeing to the release at the end of the contract, and you do not have to do that. There's nothing. It's all a matter of negotiation. If you don't want to agree to the release, cross it out. If anything's unsatisfactory, then the buyer gives that report to the seller and requests the termination of the agreement, or gives the seller a written corrective proposal, or asks for credits. Now, that's all got to be done within the contingency period. So if you got 15 or 20 days, you've got to do that. If you miss that, that's your ability, if you're a buyer, to terminate the contract. That's the time when the seller is obligated, but the buyer isn't obligated to buy. So if you miss that in that time period and you're the buyer, then you've got a 5-day period of negotiation. Neither the buyer nor the seller can terminate. You've got 5 days. The buyer can either accept the contract the way it is or negotiate. And if at the end of that 5 days, there's no agreement, then the buyer gets 2 more days to either accept the property the way it is or terminate. If the buyer doesn't do anything, you're the buyer and you don't do anything, and you don't extend this period in time, this 2-day period in writing, then you're going to agree to accept the property as it is and agree to the release. Again, you're always agreeing to the release contract. Paragraph 26, default. Okay, let's suppose that the buyer changes their mind and they want to default. There's a spot in the contract, paragraph 26G, that's a liquidated damages provision that limits the seller's revenues. Often this is checked all the time, and nobody thinks of this, but it's really inherently, in my opinion, unfair unless you're going to limit the buyer's remedies to the same amount. If you've got a $500,000 house and you get a $2,000 deposit, and you get the closing, the buyer says, you know what, thanks very much, I found a house that's cheaper, so I'm going to buy the other house, keep the $2,000, and that's the extent of your damages. The amount in that paragraph should represent the loss, the measure of damages experienced by the seller. Right now, I would tend to cross that. I wouldn't check it. If I checked it, and if it's checked and I'm representing the seller, I'm going to either have them ask the other side to remove that, or to put a provision in there where the seller's damages are limited to the same amount. Mediation. I'm going to sue. Well, maybe, maybe not. If you don't strike this clause, paragraph 27, you can't file a lawsuit in court until you satisfy this clause. It means you have to go to mediation. Mediation can be a really good thing. Mediation is one of the few remedies where the parties actually determine the outcome. You know, arbitration, you have a third party decide. Go to court, you have a third party decide. If you exercise, if you go to mediation, then the buyer and the seller attempt to work out a deal. Now, I would typically want to strike this clause, especially if I'm the buyer. It limits the form of choice. Usually, you have to go to the local board, you know, and that may or may not work. But if I'm a seller, you know, I'm not going to like this clause either, because if I don't want to negotiate, or if I'm a buyer and I don't want to negotiate, it could be determined that you're acting in bad faith and be liable for attorney fees for the other side after mediation if there's a lawsuit filed. And this clause survives settlement. Again, a few of these clauses actually say they survive settlement. This is one of them, and it makes sense. But you can always strike this and later agree to mediate. It's a voluntary proceeding, so you don't. If you've got an issue, mediation can be a lot cheaper and faster than a lawsuit. My preference is, if I've got the choice, to strike this provision. Oh, paragraph 7, fixtures and personal property. This doesn't result in a lot of lawsuits, but it results in a lot of problems at closing. Okay? The first part of it starts with a warning to be specific to tells the parties, look, put down what's included and what's not included. And it lists a whole bunch of stuff that you've got to really read. You got to read this paragraph. I mean, it's detailed and it's got a whole bunch of things in it, but this paragraph can save you a lot of aggravation if you read it and know exactly, if you're the buyer, what you're getting, and if you're the seller, what you're including. Things that are not included are the refrigerator, the washer, or the dryer. So they're not standards. They're not typically included, but you can always put them in. And there's a warning in there that some things may be leased, like solar panels, satellite dishes. You, as a seller, you want to look at that, look at that paragraph, and if you're the buyer, you want to know, seller wants to disclose and the buyer wants to know if some things are leased. And then it also has a spot there where the parties can put in excluded items. So if you're a seller, you want to exclude certain things, you want to place that specifically in this paragraph. So if a better way to deal with this is, if you have grandma's chandelier that's worth a lot of not just money but sentimental value, you may want to take that down and go to Lowe's or Home Depot and put up a less expensive chandelier that you can leave with the house, because once the buyer sees it, the buyer may decide that's got to be part of the deal. The representations on paragraph 10H, the Internet of Things. Smart houses have things where your phone can control the heating, control the lights. It can open the garage doors. This paragraph obligates the seller to clear all the data in the stored devices, so that after closing, they can't sit down at the end of the street and open up your garage and close your garage and turn on the lights and turn them off. And it also obligates the buyer, if they're not clear, to clear them. Again, this paragraph survives settlement specifically, and it's happened where sellers or the seller's kids have smartphones that can activate the devices, and they have fun after closing and start to open and close and turn things on, turn things up. So you want, that's, this paragraph says you got to clear those devices. Now, the price escalation addendum is not a clause in the standard contract. It's an addendum. It's not part of the first 14 pages. But because it's a seller's market, there are bidding battles where you have 10, 20, has traditionally been 30 offers. This lets you increase your offer in certain increments up to a maximum. So you can agree to pay, I'm going to pay you $100,000 for your house, but I'll increase my offer by $1,000 over the highest offer you have up to a certain amount. So I'll increase by $1,000 up to say $120,000. So if there's an offer over 120, I'm not going to pay that. But if there's an offer of 118 and I agree to pay $1,000 more than the next best offer, I'm going to pay $119,000. And also in this, when you change sales price, then other provisions in the contract are affected. And the mortgage contingency clause is one of those, because if you agree to get 90% loan of a $100,000 house and then you pay $120,000, this clause helps you change that. Although I don't think it does a great job, I would use this clause, but if I was the successful buyer, I would probably have an addendum that clarifies exactly what the new mortgage amount is going to be, if there's going to be a mortgage involved. And the buyer is obligated to provide a pre-approval letter. I think it's within 5 days after the acceptance to show that they actually are qualified for that new loan amount. And there may or may not be an appraisal contingency that's attached that can affect whether or not the buyer has to buy, depending on what the property appraises for. This, to keep the seller honest, the seller has to give a copy of the competing offer, except they can redact the buyer's name, to the successful buyer. And the buyer agrees that if the lender or the title company or the agents request that the buyer initial or sign any changes, they don't really have to, but there's a provision there that says, hey, I'm a buyer, yeah, I'm going to cooperate, and I'll, even though I don't have to, I'll initial or sign additional paperwork to verify that, yes, I did change my offer, and I do agree to pay at the higher price, and I do agree to change the other terms like the loan amount. The appraisal contingency addendum. You can't use this. This is another addendum that you're going to see in most contracts. Not part of the first 14 pages, but you're going to want to know about this because it can favor the buyer or the seller depending on which box is checked. So you can't use it with FHA or VA loans because the buyer doesn't have to buy if the house doesn't appraise for the sales price. So you only use this for when conventional loans are involved. Clause 1, if the purchase price is lower or if purchase price is lower than the sales price, then you've got options to terminate the contract. And there's a contingency period you put in here. Usually this goes along with the mortgage because the appraisal is part of the mortgage, but you have so many days within which to exercise this option to get the appraisal. Option 1, again, if the appraisal is okay or the appraisal isn't, you can notify the seller and you can negotiate if the appraisal comes in low. So it's better for the buyer. And option 2 is better for the seller. It says the buyer is still going to complete the sale. So you gotta know when you're drafting these things within the context of the strength of your negotiating position, what you want to keep and what you don't want to keep in the contract. So those are the clauses for today. Thank you for attending. If you have any questions, please feel free to email me at keith@keitheliou.com or call me with my direct extension. It's 412-921-7100 extension 13, and we will see you at the next seminar. Thanks for attending.